Greetings and welcome to Law of Evidence, Constitutional Issues, Invoking, Rebutting, and the Effect of Presumptions. We'll check the audio here. As I suspected, there we go. We should have good level now. So, once again, greetings and welcome to Law of Evidence, Constitutional Issues, Invoking, Rebutting, and the Effect of Presumptions from American Jurisprudence. So let's get right down to the text. Greetings to everyone in the chat. Captain Jack, greetings to you. And Less TV is always better. Love the drums. Great. Glad you enjoyed. And it is, technically a Saturday morning here on Eastern time, but you can still consider it Friday night in some places. That said, let's get started. So we've successfully completed letter A of Law of Evidence, which went over presumptions. Now we're going over B, the introduction regarding presumptions. Now we're going over letter B, which is constitutional issues affecting validity of presumptions. So we're moving ahead. Section A was rather large and lengthy and detailed, but from that we get a very deep understanding of the law of evidence regarding presumptions. So, that said again, let's get started. Constitutional issues affecting validity of presumptions. And again, the validity is what actually happens. This is if it's doing the right thing. Section 190 in civil litigation. And before we go any further, just to remind everyone that this is strictly for the entertainment educational purposes of the YouTube broadcast, not to be used, misconstrued, mispurposed for anything other than this broadcast, not to be used for anything personal, private, lawful, legal, financial, tax, or otherwise. So please don't do this at home. That said, let's continue. Because a presumption is a procedural rule that, at most, imposes the burden of persuasion, presumptions in civil litigation generally do not raise constitutional issues. Accordingly, whenever a legislature may enact legislation directly imposing liability on proof of certain facts, it may instead provide that those facts create a presumption which shifts the burden of persuasion on the ultimate issue. Wow. Pretty dense first paragraph. I'll let American Jurisprudence break it down as it normally does here. Where a presumption intrudes upon a significant liberty interest, however, it may violate due process of law. Barring special circumstances, however, all that is required is that there be some rational connection between the basic fact and the presumed fact. Just some rational connection. That's the burden. Interesting here that when a presumption intrudes upon a significant liberty interest, it may violate due process of law. How many presumptions intrude on significant liberty interests? So, barring special circumstances, all that is required is that there be some rational connection between the basic fact and the presumed fact. What's that rational connection? That's the unrebutted inference. A court assessing a constitutional challenge to a conclusive presumption assesses the adequacy of the fit between the classification and the policy that the classification serves. Thus, its constitutionality is measured by the same standards as are substantive rules of law generally. So the court, when it's assessing a constitutional challenge to a conclusive presumption, assesses the adequacy of the fit between the classification and the policy that the classification serves, the intention and the adequacy of it, filling that intention. That's where we get to validity. It may be indeed doing the right thing, right? Or doing it the right way, but does it do the right thing? And that's where does the policy, right, that fits into this whole piece here. Thus, its constitutionality is measured. That's your objectivity here, to give an objective measure of constitutionality. And it's done by standards. What standards are we using for the measure? Substantive rules of law generally. Substantive rules of law is the objective measurement by which its constitutionality is measured. So let's look at these footnotes here, 70, 71, 72, and 73. Usury versus Turner Elkhorn Mining. Supersede on other grounds. All right, so we just have the citations. All right, well, that takes us on to the supplement for Section 190 in civil litigation. Now remember, we were just saying here, because the presumption is a procedural rule that imposes a burden of persuasion, the presumptions in civil litigation generally do not raise constitutional issues. Generally. So in civil litigation, reputable presumptions, which merely shift to challenging party burden of presenting credible evidence of non-receipt of mailed notice, are constitutional. So rebuttal presumption, so you're rebutting their presumption, which merely shift the challenging party burden of presenting credible evidence of non-receipt of mailed notice, are constitutional. So you're saying you did not receive it. That would be a burden of presenting credible evidence, saying you did not receive it or they did not receive it. They would have to present credible evidence of non-receipt. And that's considered constitutional. And that's 1993. Remember, this is a 1998 edition. So these supplements here, I guess cases that have been appealed and went through the circuits and such and back or whatever it did to end up in this supplement. Although it is rather old, it is still relevant due to the fact that the law of evidence really hasn't changed much, or if at all, and if it even should. So we're on to section 191, rational connection test for presumptions and inferences in criminal cases. Before we get on that, let's jump over here to the chat. See where we're at here. Give a quick refresh. Make sure y'all can hear me. Give a little heads up in the chat. Appreciate it. And we're going to continue. A criminal law presumption violates due process if there is no rational connection between the fact proved and the ultimate fact presumed. If the evidence of one, or if the inference of one from proof of the other is arbitrary because of the lack of connection between the two in common experience. So, another dense paragraph here from American Jurisprudence, and let's break it down and let's Les do his thing. Thank you, Les TV. For example, the necessary rational connection has been found wanting where the presumptions directed that possession of marijuana or cocaine was sufficient evidence to permit conviction of the crime of transporting and concealing it with knowledge of its illegal importation, unless the defendant explained otherwise to the jury's satisfaction. As to the heroin, however, the presumption has been held that not arbitrary and not a violation of due process. Look at this. The necessary rational connection has been found wanting where the presumptions directed that the possession of marijuana or cocaine was sufficient to permit conviction and concealing it with knowledge of its illegal importation, unless defendant explained otherwise to the jury's satisfaction. For example, the necessary rational connection has been found wanting. Oh, okay, I see here. Okay, so with the Harrigan case here, the presumption has been held not arbitrary and not a violation of due process. 76. Okay, nothing on that. And the other one, this is Turner versus United States. Same thing. So the probability, and now we'll get the explanation of it. Okay, here we get the explanation. The probability that the drug had been imported was insufficient. The probability is insufficient to sustain the presumption, and that to presume knowledge of importation from mere possession was so dubious as to be arbitrary. Okay, there's the clear language. The probability that the drug had been imported was insufficient, not high enough probability that it had been imported to sustain the presumption, and that to presume knowledge of importation from mere possession was so dubious as to be arbitrary. All right, that's a nice one there. And that makes sense now. Let's continue. The constitutionality of an instruction to the jury that possession of recently stolen property, if not satisfactorily explained, is ordinarily a circumstance from which it may reasonably draw the inference that the person in possession knew the property had been stolen, has also been upheld. See footnote 74, holding a violation of due process, the statutory presumption that the possession of a firearm shall be presumptive evidence that such firearm had been shipped in interstate commerce, because it ignored the substantial possibility that the defendants might have obtained the firearms from an interstate source. A presumption that someone present at an illegal still was in possession of it failed both the rational connection and the judicial instruction test because, although presence tells us the defendant very likely played a part in the illicit scheme, it provided no legitimate, rational, or reasonable inference that he was engaged in one of the specialized functions connected with possession, rather than in one of the supply, delivery, or operational activities having nothing to do with possession. United States versus Romano. Clear connection between, and that's of course from Prohibition days, right? Because we're talking about a still. The clear connection between the basic fact, presence at an illegal still, and the presumed fact, in essence, any criminal involvement in its operation passed the rational connection test because presence at an illegal still strongly suggested that the defendant was a participant in its operation. That's United States versus Gainey. I don't think I'll drink to that. Right, we read that one, and we're on to Barnes versus United States, holding that the nexus, the connection between the facts and the legal principles here, between the basic fact and the presumed fact, was clearly sufficient to enable the jury to find beyond a reasonable doubt that those in the unexplained possession of recently stolen property know it to have been stolen. Right, we're on to section 192, tests for mandatory and permissive presumptions or inferences. Interesting. Jumping over here to the chat, see if we have any questions, details, comments, and we shall continue. The degree of persuasiveness required to uphold a criminal law presumption depends upon whether the presumption is permissive or mandatory. A permissive inference, that is, one from which the jury may, but not need to, infer the presumed fact from the basic fact, satisfies due process so long as a rational fact finder could conclude that, once the basic facts are proven, the presumed fact is more probably than not also true. A mandatory presumption of the criminal law, that is, one from which the jury must find the presumed fact from the basic fact unless the defendant persuades it to the contrary, satisfies due process only if a rational fact finder convinced that the basic facts are true and relying only on the basic facts, could find beyond a reasonable doubt that the presumed fact is also true. So a mandatory presumption of criminal law is one from which the jury must find the presumed fact from the basic fact unless the defendant persuades it to the contrary, satisfies due process only if a rational fact finder, convinced that the basic facts are true and relying only on the basic facts, could find beyond a reasonable doubt that the presumed fact is also true. So, jury must find the presumed fact from the basic fact is the mandatory fact, but that's unless, we're considering here from a prosecutorial standpoint here, unless the defendant persuades it to the contrary, satisfies due process. Only if a rational fact finder convinced that the basic facts are true and relying only on the basic facts, now we're at a different level here, could find beyond a reasonable doubt that the presumed fact is also true. So could. Footnote 79. Court County of Ulster County versus Allen. Great. That looks like a lot of stuff on that one. So here it is here. Stressing the distinction between two types of evidentiary device. Remember, evidentiary devices, not evidence per se. A permissive inference or presumption, what is referred to in civil litigation as an inference, and a mandatory presumption, in essence, a presumption that requires the defendant at least to raise a reasonable doubt as to the presumed fact. Okay, so requires the defendant at least to raise a reasonable doubt as to the presumed fact. Where the judge has told the jury it may ignore the presumption, even in the absence of contradicting evidence, its validity is assessed, not in the abstract, but in the light of all evidence in the record. But to the extent that the trier of fact is forced to abide by a presumption, and not reject it based on an independent evaluation of the facts presented by the prosecution in the particular case, the analysis of the presumption's validity is logically divorced from those facts, and hence must be assessed on its face, without regard to any other evidence that has been introduced at trial. Same case. So this one's a landmark. Wow, so where the judge has told the jury it may ignore the presumption, even in the absence of contradicting evidence, its validity is assessed not in the abstract, but in the light of all evidence in the record. Wow. But to the extent that the trier of fact is forced to abide by a presumption and not reject it based on an independent evaluation of the facts presented by the prosecution in the particular case, the analysis of the presumption's validity is logically divorced from those facts, and hence must be assessed on its face. So back to the validity. Is it being constructed right, or is it doing the right thing? Validity is it doing the right thing? So if it's logically divorced from those facts, hence it must be assessed on its face without regard to any other evidence that has been introduced at trial. So observation. Let's get to this so we can make clarity here. The ultimate test of either type of presumption has mandatory or what was the other one? Permissive. Is whether the inference or presumption undermines the fact finder's responsibility at trial based on evidence adduced by the state to find the ultimate facts beyond a reasonable doubt. So the ultimate test of either type of presumption is whether the inference or presumption undermines the fact finder's responsibility at trial based on the evidence adduced by the state to find the ultimate facts beyond a reasonable doubt. Right, and we're on to section 193, probability. We're going to jump over here to the chat and make sure we're up. Yeah, validity divorced from facts. Interesting concept they have here, but I think what they're getting at is the fact that let's see here, where'd it go? There it is, the observation. So the test is whether the inference undermines the fact finder's responsibility at trial. And that's based on evidence brought in by the state to find ultimate facts beyond a reasonable doubt. So does it undermine the responsibility? That presumption, is it undermining responsibility? And that's where I think we have right here that the trier of facts is forced. You see, when you're undermining that responsibility, if they're forced to abide by a presumption and not reject it based on an independent evaluation, which is their responsibility, of the facts presented, adduced by the state, presented by the prosecution in the particular case, the analysis of the presumption's validity is logically divorced from those facts and hence must be assessed on its face. So what it's saying is based on, right? The ultimate test is whether the presumption undermines, based on the evidence adduced by the state, to find the ultimate facts beyond a reasonable doubt. So logically divorced from those facts, I think, is looking at the, remember we're talking about the presumption, is whether the ultimate test of it undermining is going to be the particular case analysis, right? To see if it's the validity is logically divorced. So that comes back to the ultimate facts beyond a reasonable doubt, which will be the validity, whether it's doing the right thing. So if it's the presumption undermines a fact finder's responsibility, right, based on evidence adduced by the state to find the ultimate facts beyond a reasonable doubt. In this case here, saying, and not reject it based on an independent evaluation of the facts presented by the prosecution in the case. The analysis is logically divorced and hence must be assessed on its face. So it's saying that it must not be undermined, otherwise it would be logically divorced, and it wants to be related on its face. All right, let's proceed from this. I hope that became clear as mud. But I think we got a pretty good multifaceted look at that. Don't want to dwell too long. Even in the face of contradictory evidence, no, that would be the difference. If there's contradictory evidence, it says here, then that would invalidate it. Or that's not the word they used here. Let's see here. What was the word they used? Well, yeah, the analysis of presumptions of validity. So it's assessed on its face whether it's going to be valid or not, and whether it's undermining the fact finder's responsibility. So, yeah, it would be, again, what we're saying here again, that the defendant here persuades it to the contrary, satisfies due process only if a rational fact finder convinced that the basic facts are true and relying on the basic facts could find beyond a reasonable doubt that the presumed fact is also true. So the mandatory presumption is one where the jury must find the presumed fact unless the defendant persuades it to the contrary. So there's your burden of persuasion on the defendant if it's a mandatory presumption. So, all right, let's continue on here to probability. Once again, ready to sit for the bar, clear as mud. Yeah, you don't want to sit for the bar for this, but I think we're getting this stuff takes a while to sink in, and that's the whole purpose of the way it's structured here in American jurisprudence is that it's viewed at from so many different angles. Eventually, it starts to crystallize in your mind to the fact where you can synthesize solutions from any kind of situation you may find yourself in. That's the ultimate goal here. All right, the factual probability of the presumed fact must be much greater for a mandatory than for a permissive presumption. Now, I would assume that the factual probability must be, I would say, much greater. Of course, a permissive inference or presumption allows but does not require the fact finder to infer the presumed fact from proof of the basic fact and places no burden of any kind on the defendant. Therefore, the constitutionality of a permissive inference or presumption is assessed against a comparatively liberal standard. That is, a permissive inference or presumption complies with due process so long as a rational fact finder could conclude that the presumed fact is more likely than not to flow from the basic fact. Okay, let's see these footnotes. Do they have anything interesting in here? That ulster's back. Permissive presumption leaves the trier of fact free to credit or reject the inference and does not shift the burden of proof. It affects the application of the beyond a reasonable doubt standard only if, under the facts of the case, there is no rational way the trier could make the connection permitted by the inference. Let's read that one more time. Permissive presumption leaves the trier of fact free to credit or reject the inference and does not shift the burden of proof. It affects the application of the beyond a reasonable doubt standard only if, under the facts of the case, there is no rational way the trier could make the connection permitted by the inference. So, reasonable doubt is not affected unless there's no rational way they can make that connection. So, the arbitrary use of C not followed on other grounds. That Ulster, Turner and Ulster. Giving an instruction. Have we got to this footnote yet? 85? I don't think so. Let's continue here. Yeah, we're on 84. A mandatory presumption, on the other hand, may affect not only the strength of the no reasonable doubt burden, but also the placement of that burden. It tells the trier that he or they must find the elemental fact upon proof of the basic fact, at least unless the defendant has come forward with some evidence to rebut the presumed connection between the two facts. Thus, a mandatory presumption is constitutional only if a rational fact finder who was convinced of the basic facts could, without considering any other evidence, find the presumed fact beyond a reasonable doubt. So, beyond a reasonable doubt standard for the mandatory presumption to keep it constitutional. Mandatory presumption need not, however, be accurate in every imaginable case, so long as it passes the rational fact finder beyond a reasonable doubt standard. Let's get on to these footnotes here. 85, Romano, Ulster. Okay. Giving an instruction that there is a mandatory presumption of intent to steal from failure to return rented property within a specified period could not be a harmless error. Wow. Overruled on other grounds in another case. Instructing the jury that the acts of a person of sound mind and discretion are presumed to be the product of the person's will, but the presumption may be rebutted and that a person of sound mind and discretion is presumed to intend the natural and probable consequences of his acts. But the presumption may be rebutted, violated due process. But the presumption may be rebutted, that the acts of a person of sound mind and discretion are presumed to be the product of the person's will. That person's sound mind discretion is presumed to intend the natural and probable consequences, but the presumption may be rebutted. Violated due process. So I guess you can't rebut that one, at least not easily. Trial judge's instruction to the jury that the law presumes that a person intends the ordinary consequence of his voluntary acts violated the Constitution because it communicated to the jury that the state did not have to prove the element of intent. Wow. That's interesting there. The trial judge's instructions that the law presumes that a person intends. Wow, that a person intends the ordinary consequences of his voluntary acts violated the Constitution because it communicated to the jury that the state did not have to prove the element of intent. Even though an instruction of this type might provide that the presumption of intent could be overcome by other evidence, the deprivation of due process persists. So it's not just about the presumption being overcome by other evidence, it's the deprivation of due process. And that's why we're talking about the constitutionality here, because that's where most of this falls under, is due process, as we read. And back to Ulster, criticizing the Second Circuit for invalidating a presumption because it might not be valid in implausible hypothetical situations. Wow, that must be an interesting case. Probably why we see all these references to it. All right, so we got through that. Now we're on to Section C, the effect of presumptions. Interesting here. On to 194, section generally. Okay, let's jump over here to the chat. Assumption and color of law. What could possibly go wrong? What could go wrong is not enough rebuttals, not enough challenging of assumptions and presumptions, and poor inferences, arbitrary decisions. I guess I need to review reasonable doubt. How reasonable? Really reasonable. We went over reasonable doubt actually a couple times, and I have to say that was thanks to Captain Jack, one of the subscribers here. And we've actually run over it a couple times through here. But the reasonableness of something is something that would be expected by, the generally accepted by people in society in the conditions and the subjects and the situation involved. And we say reasonable doubt. We went on there's a whole episode here on the playlist about beyond reasonable doubt, and it gets into extensive detail about that. That said, we'll have enough clarification as we go along here. So hang on there. The traditional theory treats a presumption as merely a procedural device whose purpose is merely to facilitate the trial process by shifting the burden of production as to a presumed fact from one party to another, but not the burden of persuasion. So the burden of production can be shifted, but not the burden of persuasion. That's a traditional theory treats a presumption as merely a procedural device whose purpose is merely to facilitate the trial process by shifting the burden of production as to a presumed fact from one party to another, but not the burden of persuasion. So, footnote 88. Let's look this one over here. And, okay, too much there. Nationwide Mutual. Oh, here we go. Annotation, comment, note. Effective presumption is evidence or upon burden of proof where controverting evidence is introduced. Oh, okay. All right, let's just continue on the text. The reformist theory. So that was our traditional theory. Okay, so we're looking generally here at theories of presumptions. So the traditional theory, it's a procedural device. Purpose is to facilitate trial process by shifting burden of production, but not burden of persuasion. The reformist theory objects that presumptions are created to deal with significant concerns of procedure and policy. By treating a presumption as little more than a permissive inference with minor procedural appendage, which disappears once the adversely affected party verbalizes a denial of the presumed fact. The probability theory similarly reasons that any presumption that is based upon logical probability, that is, one in which the basic facts have probative value of the existence of the presumed fact, ought to shift the burden of persuasion to the party adversely affected by the presumption. Interesting. So burden of production by one party, shift the burden of persuasion to the party affected by the presumption. Wow, it's footnote 90. Applying the probability theory to the presumption of accidental death rather than death from or violation of law. Wow, or violation of law. Well, that's going to be an interesting case there. Life insurance. So we have these two theories, a traditional theory and a reformist theory. And it objects that presumptions are created to deal with concerns of procedure and policy. By treating a presumption as little more than a permissive inference with minor procedural appendage, which disappears once the adversely affected party verbalizes a denial of the presumed fact. So the probability theory similarly reasons that any presumption is based upon logical probability. That is, one which the basic facts have probative value of the existence of the presumed fact ought to shift the burden of persuasion to the party adversely affected by the presumption. Public policy theory. So we got another one, the public policy theory. Reasons that if a presumption's primary purpose is merely to facilitate the trial process, it should shift only the burden of production. And that's getting back to a traditional one here, where it shifts the burden of production. If a presumption was created to help implement a broader social policy, however, it should also shift the burden of persuasion. Oh, wow, social policy. The practical difficulty with this approach is that most presumptions reflect a mixture of procedural and policy concerns. No kidding. So, rationale for presumptions, section 185. I think we went over this one before. We did. Maybe it was because it's so distasteful it doesn't linger as well. So we have a public theory, a reformist theory, and a traditional theory. There's also the probability theory, and it's similar to it's based upon the logical probability. So, as it's saying here, is little more than permissive inference with minor procedural appendage. So there's some procedures added with the inference, right, which disappears once the adversely affected party verbalizes, just verbalizes a denial of the presumed fact. Interesting here, and we get our footnotes that we've already been over here. So we're on to section 195 under Federal Rule 301 and other similar state rules. This one should be interesting here. Rule 301. Let's jump over to the chat briefly. Stay dangerous, stay free. YouTube Less TV. We'll be keeping it going here for you. You can always check it on the replay. It'll be there. All right, let's get back onto it. Rule 301 of the Federal Rules of Evidence provides generally that in all civil actions and proceedings, a presumption imposes on the party against whom it is directed the burden of going forward with evidence to rebut or meet the presumption, but does not shift such party the burden of proof in the sense of the risk of non-persuasion, which remains throughout the trial upon the party on whom it was originally cast. Congress rewrote Rule 301, which was promulgated by the Supreme Court. Wow, shifted both the burden of going forward and the burden of persuasion. While Rule 301 of the Uniform Rules of Evidence does not directly address this issue, some state variations of Rule 301 follow the federal text that presumptions do not shift the burden of proof. Courts in these states generally follow federal interpretations when interpreting their own state provisions. Several additional states have adopted the substance of Rule 301 by judicial decision. According to Rule 301, once a party has introduced sufficient evidence rebutting the presumed fact, the presumption, as such, drops out of the case. That's an important aspect here. Once a party has introduced sufficient evidence rebutting the presumed fact, the presumption as such drops out of the case. Rule 301 applies only in civil actions and proceedings, not in criminal trials. As we are reading in the introduction, that the probability theory applies mostly in civil actions, as the burden of proof is much higher for criminal. And then, of course, the conclusiveness of it. The rule also acknowledges that some presumptions should receive different treatment, but only if otherwise provided for by act of Congress or by the rules themselves. You see, this is important here. Some presumptions should receive different treatment, but only if otherwise provided for by act of Congress. If there's not an actual statute at large, then there's nothing that's that would acknowledge they should receive different treatment, or by the rules themselves. A presumption is clearly regulated by Rule 301 if its legislative history so specifies. But if the language codifying a statutory presumption explicitly directs a shift in the burden of persuasion, it clearly falls outside the provisions of Rule 301. Let's see here, footnote 2. Wow, Wilson versus Omaha Indian Tribe. Where court considered the impact of 25 U.S.C. 194, which provides that in all trials about the right of property in which an Indian may be a party on one side and a white person on the other, the burden of proof shall rest upon the white person. Whenever the Indian shall make out a presumption of title in himself from the fact of previous possession or ownership. Provides that in litigation over the validity of a patent, once a patentee introduces into evidence the letters of patent used by the Patent and Trademark Office, a patent shall be presumed valid, and the burden of establishing invalidity of a patent or any claim thereof shall rest on the party asserting invalidity. The Federal Coal Mine Safety Act of 1969, which provides that in an action for benefits, if a miner was employed for 15 years or more in an underground coal mines and evidence is introduced that demonstrates the existence of a totally disabling respiratory or pulmonary ailment, then there shall be a rebuttable presumption that the miner's disability or death was caused by Alabama. Presumptions issued by a regulatory agency that require the adversely affected party to establish the non-existence of the presumed fact come within the exception. So regulatory agency, non-existence come within the exception that we were reading about. Recognizing the congressional intent argument, but holding it inapplicable to the Federal AIDS Highway Act of 1916, now codified at 23 U.S.C. Wow. Footnote 4. Did we get to that one yet? No. All right, so we read ahead the footnotes. Let's get back to the text. All right. So, geez, we really did get ahead of the footnotes. So, presumptions regulated by Rule 301 unless explicitly codifying. All right, I went too far, didn't I? See, no. Right. Shift and burden of persuasion clearly falls outside. Disagreement exists, however, as to a statutory presumptions that do not explicitly otherwise provide, that is, which do not explicitly direct a shift in the burden of persuasion. Plain reading of Rule 301 suggests that a statutory presumption that lacks such language is regulated by the rule without consideration either of the intent with which Congress created the presumption or of pre-Rule 301 case law interpretations interpreting the presumption. On the other hand, federal statutory presumptions that predate the federal rules of evidence were enacted at a time when Congress could not have anticipated the importance of specifying in the statute itself, rather than its legislative history, the impact the presumption should have. Thus, an across-the-board application of Rule 301 to pre-Rule 301 presumptions could, in some instances, frustrate the intent with which Congress enacted the presumption in the first place. And even absent explicit legislative history, the policies underlying the creation of statutory presumption may strongly suggest that Congress intended that the presumption to shift the burden of persuasion, or at least that Congress would have so intended if it had thought the problem, though, through. Arguably, therefore, courts should give a pre-Rule 301 statutory presumption a burden of persuasion shifting effect, not only if Congress so provided explicitly in the statute, but also if its legislative history or underlying policy considerations suggest that is what Congress intended. Here's our supplement for Section 195, similar state rules in the Federal Rule 301, case authorities. District Court's rejection of employers' asserted reasons for discharging plaintiff did not mandate finding for employee alleging racial discrimination, since under Federal Rule 301, presumption does not shift burden of proof. And Title VII, plaintiff at all times bears ultimate burden of persuasion. Holding that finding for employee was not mandated did not give special favor to employers whose evidence rebutted charges of racial discrimination was disbelieved. Fact that employers' proffered reason was unpersuasive or obviously contrived did not necessarily establish that the employee's proffered reason of race was correct, and courts should not treat discrimination differently from other ultimate questions of fact. Wow. There's all our other citations. We read these here. See, okay, so we're on to the effects of pre-rule case law. Prior to enactment of Rule 301, federal courts had traditionally held that some presumptions shifted the burden of production as well as the burden of persuasion. Wow. Applying 301 to such presumptions would affect a substantive change in law that Congress presumably did not intend or contemplate when it enacted Rule 301. Some courts, however, have concluded that burden of persuasion shifting impact of such pre-301 decisions are grandfathered into the law and survive Rule 301. Misery versus Elmore. See, holding that a presumption created to implement a provision of the Interstate Commerce Act. Wow. Oh, created to implement a precision. Oh, continues to shift the burden of persuasion despite the subsequent enactment. Okay. The law has long recognized that a presumption that a vessel which drifts into collision was at fault, and that proof of the basic facts imposes the burden of establishing that the drifting had a cause other than negligence upon those responsible for the vessel. This presumption is not governed by Rule 301 because the rule would give it insufficient weight. Although the National Labor Relations Board reliance on the presumption of continued majority support of a union may be inconsistent with Federal Rule 301 because it shifts to the employer the burden of persuasion regarding the appropriateness of the proposed bargaining unit. The presumption continues to apply. Okay, see your later proceeding. All right, and that takes us to D, invoking and rebutting presumptions. So let's see if anyone's still here along for the ride in the chat. Give a quick refresh here. Hope you're all able to stay along. If you're still here, please do remember to hit the like so we make sure we get the word out for more people. Seems the notifications have been rather thin lately. All right, we're on to proving and rebutting basic facts. The party seeking to invoke a presumption must satisfy the burden of production as to the basic facts. That is, must introduce sufficient evidence of the basic facts to survive a motion for a directed verdict as to those facts. Occasionally, a party will seek to employ one presumption to assist it in establishing a second presumption. Yeah, really. When the presumed fact is an essential element of a cause of action, the burden of production as to the basic facts must be satisfied during the case in chief. If, on the other hand, the presumed fact is merely helpful rather than an essential element, or if it rebuts a defense, affirmative defense, or counterclaim, the burden of production as to the basic facts may be satisfied at other stages in the trial. Pretty interesting. So it's saying here with the presumed fact is an essential element of the cause of action of the lawsuit, must be satisfied during the case in chief. If, on the other hand, the presumed fact is merely helpful rather than an essential, or rebuts a defense, affirmative defense, or counterclaim, the burden of production as the basic facts may be satisfied at other stages in the trial. Let's look at that footnote 11 for discussion on when it's appropriate to produce evidence at later trial stages, which we did go over previously. So it says here, I guess if a presumed fact is merely helpful, the burden of production can be satisfied at other stages in the trial instead of the case in chief. What is a case in chief? Well, I know who would know. It would be our good friend, Mr. Black. Let's take a look at what we got here at Black's Law for case in chief, if it does exist as a word here. If not, we'll know that it's terminology that we need to further find out what it means exactly. And just bear with me as this is a scanned document. It takes some time to get through it. Once it starts moving though, it goes a little faster. Here we go. Case in chief. We should be pretty close to it here. Let's see what we got here. All right, now it's scrolling. There we go. Case dated. Case at bench. Case in chief. Let's see it here. Let's see here. Case reserved. Case stated. Active, instant reference, test case. Here is case in chief. 1853. The evidence presented at trial by a party between the time the party calls the first witness and the time the party rests. That's the case in chief when the evidence. Oh, okay, between the first witness and the time the party rests, the part of the trial in which the party presents evidence to support the claim or defense. Rebuttal. Okay, nice. Case law. I like it's one word. Did anyone know that? It's supposed to be one word? Case law? Like coleslaw. Interesting there. All right, well, I digress. Let's get back to the topic here. All righty. So, when the presumed fact is an essential element of a cause of action, the burden of production as to the basic facts must be satisfied during the case in chief, between the first witness and the resting of the case. If it's just helpful, burden of production as a basic fact may be satisfied at other stages, so pre-trial, I assume, other things. All right. Nice. Okay, so we're on to section 198, satisfying and shifting. Burden of production. Now we're getting into some heavy hitting. By satisfying its burden of production as to the basic facts, party triggers the presumption. So once you satisfy that burden of production to the basic facts, the presumption is triggered. This has a twofold procedural impact. First, the presumption satisfies a party's burden of production as to the presumed fact and enables a party to survive a motion for a directed verdict. Secondly, the presumption also shifts the burden of production as to the presumed fact, a principle which is codified in many evidence codes and recognized in the coleslaw of several states. If the party relying on the presumption satisfies its burden of production as to the basic facts, and the party adversely affected by the presumption fails to satisfy its burden of production to rebut the presumed fact, the latter party suffers a directed verdict as to the presumed fact. In a non-jury trial, if a court finds the basic fact is true, it must also find that the presumed fact is true. In a jury trial, the jury is instructed that if they accept the basic facts as true, they must also accept the presumed fact as true. Wow. So there's where our directed verdicts. If the burden of production to rebut the presumed fact fails to be satisfied. Section 199, we'll get to that shortly. The discussion of the requirements to rebut a presumed fact. Took a long time to get there. We're just about there. But first we need to read this one here. Effect of a presumption to create a prima facie case on which a judgment may be rendered in the absence of contrary evidence. Okay. Presumption is a deduction, which in the absence of rebuttal evidence, the law requires the fact finder to make if it finds the basic facts. So it's a deduction, which in the absence of rebuttal evidence, the law requires a fact finder to make if it finds the basic facts. Phew. A presumption is a conclusion that is mandatory if not rebutted. Unrebutted inferences is your presumption. If a fact finder finds the basic facts, it must find the presumed fact in the absence of evidence to the contrary. A presumption makes out a prima facie case which is dispositive in the absence of contrary evidence. A presumption is binding on the jury unless sufficiently rebutted. A presumption is mandatory unless rebutted. Once one case adopted a position directing that the judge instruct the jury that if it finds the basic facts, it should find the presumed fact, unless it believes the non-existence of the presumed fact is at least probable as its existence. So if the non-existence is as probable as its existence, then it should find the presumed fact. So we have forms here, effect of uncontroverted disputable presumptions in the instructions for the jury. Presumption is based on basic fact, and that comes from our pleadings and practice forms in American jurisprudence. Now we're on to the best part. So those of you who have stuck around, you get the Easter egg here, section 199, rebutting presumed fact. Courts have expressed the burden of proof that the adversely affected party must satisfy in order to avoid an instruction that if the jury finds a basic fact, it must also find the presumed fact in a variety of ways. Here we go. The evidence rebutting a presumption must be substantial, credible, positive, or must be sufficient to raise an issue of fact for the jury, or put the issue in equilibrium. That's meaning just as much possible or as impossible, right? Or what was the terminology we had here? Lord, where'd it go? Yeah, there was some good language in here. Let's see here. Well, I digress. Yeah, there's burden of production. I must have been one of these footnotes here. Yeah, here it is. One case adopts a position. It should find the presumed facts unless it believes the non-existence of the presumed fact is at least as probable as its existence. So 50-50 or better, right? Let's go on here. Thanks for that. Hanging in for that digression. So there it is. Equilibrium. Other courts have held that any evidence having a tendency to support the non-existence of the presumed fact will suffice. With regard to a typical presumption, therefore, to avoid a directed verdict as to the presumed fact, the party adversely affected by the presumption must offer sufficient evidence to permit a rational fact finder to find the non-existence of the presumed fact by a preponderance of the evidence. Once the party adversely affected by the presumption offers sufficient evidence rebutting the presumption to avoid a directed verdict as to the presumed fact, the presumption drops out of the case and the burden of persuasion as to the presumed fact remains with the party who had that burden at the outset of the trial. Nice. So here's the better language on this. Adopting the formulation that a presumption persists until the contrary evidence persuades the fact finder that the balance of probability is in equilibrium, or stated otherwise, until the evidence satisfies the jury or fact finder that it is as probable that the presumed fact does not exist as that it does exist. Then we have the production of evidence disputing or contrary to the presumption causes the presumption to disappear, where such evidence to the contrary either counterbalances the presumption or even when it is only sufficient to leave the case in equipoise. And we have the annotation. Comment, note, affect the presumption as evidence or upon burden of proof, where controverting evidence is introduced. That's an American Law Review. Instruction of jury forms. Non-existence of presumed fact. A presumption is not evidence, as we read before, and its sole function is to take the place of evidence so that when the latter appears, if only to the extent that an inference may be drawn from it, the presumption vanishes. Wow. Take the place of evidence so that when the latter appears, the evidence appears, if only to the extent that an inference may be drawn from it, the presumption vanishes. Wow, the presumption of descendants' due care disappears from the case when any evidence is introduced tending to establish negligence. Wow. So that's explaining it even better. Pretty personal terms there, huh? Okay, so now we're on to pyramiding presumptions or inferences. I like this, pyramiding presumptions. While the basic facts of a presumption may be proved by circumstantial evidence, it is often said presumptions must be based on facts and not upon inferences or upon other presumptions. Similarly, it is often said that an inference may not be based upon another inference, although this statement has been criticized as an inaccurate and confusing expression of the principle that an inference cannot be based upon evidence which is uncertain or speculative, or which raises merely a conjecture or possibility. Other courts permit pyramiding inferences or presumptions. Yikes. 29. United States versus Eustis. Florida, great. Alabama, Tennessee. California. All right. Under this view, if the inferences and underlying evidence are strong enough to permit a rational fact finder to find guilt beyond a reasonable doubt, a criminal conviction may properly be based upon pyramiding inferences. If the inferences are too weak, or the conclusions the prosecutor seeks to have drawn from them are too speculative, a conviction based thereon must be set aside. So weak inferences or the conclusions the prosecutor seeks to have drawn from them are too speculative. The conviction must be set aside. Courts which permit passing an inference on an inference often differ as to how persuasively the primary or basic inference must be proven before a second inference may be drawn from it. Some insisting that a second inference may be drawn from a first inference only if the first inference is shown with sufficient strength to elevate it to the equivalence of established fact, or to the exclusion of other reasonable inferences. Other courts may take the view that the basic or primary inference is sufficiently established if it is more probable than its non-existence. And then the third view is that an inference may be based upon an inference so long as neither inference is too remote, speculative, or conjectural. So we have three views here. Okay, let's see here. First one here is some insisting that a second inference may be drawn from the first only if the first is shown with sufficient strength to elevate it to the equivalence of established facts. That's a high bar. Or the exclusion of other reasonable inferences. So there's no other alternative that's reasonable. Then there's the second one. Other courts take the view that the basic or primary inference is sufficiently established, is more than probable than its non-existence, which makes it a lesser bar. The third view is an inference may be based upon another inference so long as neither inference is too remote, speculative, or conjectural. So that's a very low bar. 34. Let's see where that low bar is. Cambridge, see here. All right, ooh, where'd it go? Inference can be based on an inference. An inference cannot be based solely on an inference that is too remote or conjectural. When the only evidence that banana peel had been, this is the banana peel slip one, where the only evidence that banana peel had been on the grocery floor long enough for the store to be negligent for failing to remove it was that the peel was black. Summary judgment was improperly entered against plaintiff as the inference of negligence was too speculative because it depended upon an initial unproven inference that the peel was not already black when it reached the floor. Oh gosh, that was Winn-Dixie. Bates versus Winn-Dixie, Florida. Oh my gosh. The old banana peel slip. In action by a father for wrongful death of his child who was struck by an automobile, evidence was sufficient to establish that the defendant was the driver of the automobile who waved for the child to cross the street, and the child saw him wave and relied on his signal when stepping onto the street. Such evidence did not constitute an impermissible inference based solely on another inference where the driver's own testimony established that he was the driver, and independent evidence supported the second inference that the child saw him wave and relied on that signal. Oh, geez. That sounds tragic. All right, let's jump over here to the chat real quick and see if we're all caught up here. Is anyone still here? Is the question. All right, let's continue. Conflicting presumptions, section 201. One approach to resolving conflicting or inconsistent presumption is a more or less mechanical rule. Conflicting or inconsistent presumptions cancel each other, and the judge and jury should proceed without regard to either. A second approach requires the judge to determine which presumption should prevail, based upon factors such as public policy. However, if the considerations of policy are of equal weight, neither presumption applies. Mechanical rule. Conflicting or inconsistent cancel each other out, and no regard to either. A second approach has a judge to determine which prevails. Again, if there's a tie, neither applies. Wow, inconsistent presumptions between Paternity Act, which provide that where a blood test shows a probability of paternity of 97% or greater, the alleged father is presumed to be the father, and that the presumption may be rebutted only by clear and convincing evidence and rules of evidence, which provided that the legitimacy of a child conceived or born during marriage can be challenged only by proof beyond a reasonable doubt or disregarded. Wow. All right, and then that takes us to the end of the constitutional section, and next time we'll be on to the particular presumptions. This gets into some pretty cool stuff, and as just a teaser, the first part is going to be relating to official conduct. So, that takes us to the end of law of evidence, constitutional issues, invoking, rebutting, and the effect of presumptions from American jurisprudence. If there's anyone in the chat wants to ask any more questions, comments, input, this is the time to do it. If not, I'll be hoping to see you all in the next one, and salute to you all for sticking through this episodes. This is part 13 of Law of Evidence as we move through presumptions, which is a very important part of evidence. And we're going to continue. This is a very large volume of American jurisprudence. And once we're done with this, that's one of the strongest foundations you can have for both civil and criminal cases. So once again, salute you all for sticking with it, and we'll see you all on the next one. Peace out.